esteemed members of the teaching fraternity, distinguished guests, my dear students, அனைவருக்கும் எனது இனிய மாலை வணக்கம். Being amidst such young and bright minds always gives me a great sense of enthusiasm, and it is indeed a joy to stand before you today on this special occasion of the inauguration of the Decennial year celebration of this esteemed institution, and speak on a subject that is close to my heart, the role of mooting in shaping legal practice, insights from the bench. As someone who has spent several years both as a practicing advocate and as a judge, I have witnessed firsthand how mooting plays an instrumental role in preparing the future generation of lawyers. When I reflect on my early days as a young advocate, I recall the overwhelming sense of uncertainty we faced as we stepped into courtrooms for the first time. The real challenge was not merely knowing the law from textbooks, but articulating it, applying it, evaluating situations, and convincing an audience, where it was a learned judge or a critical client. Mooting plays a vital role in bridging this gap. It is often seen as an academic exercise, but to me, it is much more. It is training ground for the mind, a rehearsal of the art of persuasion and a simulation of courtroom practice. Moot goes for beyond academic exercise. It demands rigorous research into statutes, case law, and academic commentaries. Unlike classroom learning, mooting pushes law students to apply the law in hypothetical facts, situations that often mirror lifetime complexity. I have seen advocates come before my court who have developed the habit of carefully shifting through vast amounts of information and critically evaluating it rather than relying on superficial knowledge. This ability to analyze a legal issue from multiple angles, to not only know the law but to question it and test its applicability, is the very foundation of sound academic advocacy. As a matter of fact, this skill comes to some people naturally, but continuous participation in the moot court competitions will help you to develop such essential skills over time. One of the most visible impacts of mooting is the development of oral advocacy skills. Presenting arguments before a panel of judges in a moot court is no different from appearing before a real court. From moot experiences, students can learn to structure arguments logically, speak clearly and persuasively, and answer unexpected questions without losing composure. From the bench, I have observed that those who actively participated in moot court competitions handle the rigors of real court proceedings far better. Their ability to remain calm under pressure, respond thoughtfully to questions, and present arguments with clarity makes a tangible difference in the quality of justice dispensed. It is a discipline in itself. It teaches young advocates the importance of meticulous preparation, from the researching deeply, drafting well-organized written submissions, to rehearsing their oral presentations. It is not about last-minute effort or relying solely on innate talents, but about structured methodical work. This habit, rigorous preparation, does not end with mooting. It becomes a life skill. In court, every advocate who stands firm today is someone who has mastered the discipline of preparation. And that is exactly what the bench looks for. Clarity of thoughts, precise argumentation, and well-researched submissions. What makes mooting particularly exciting is that it is often focused on current and emerging areas of law. Data protection, environmental issues, constitutional challenges, and even matters of international law. It pushes students to stay up to date with the changing landscape of law and society. The legal profession must never remain static. It must evolve as society evolves, and mooting equips young lawyers with the mindset to think critically and about modern challenges and find creative solutions within framework of law. Finally, perhaps the greatest merit of mooting is the confidence it builds. The experience of standing before judges, defending one's argument, and handling tough questions is invaluable. It teaches resilience and courage. This confidence is not just about being able to speak well. It is about readiness to face real courtroom pressure, to uphold truth and justice even in difficult circumstances, and to carry forward the legacy of ethical and fearless advocacy. In conclusion, the role of mooting in shaping legal practice is indispensable. It is an opportunity to sharpen your mind, develop discipline, build confidence, and understand the noble responsibility that comes with being an advocate. To the students here today, I urge you not to view mooting as a mere competition or academic exercise. See it as your first real step into the noble profession of law. Prepare diligently, argue ethically, aim not merely to win but to serve justice. Let me leave you with a thought from our father of nation, Mahatma Ji, who wisely said, "An ounce of practice is worth more than tons of preaching." This is especially true in our legal profession. It is not enough to read about the law or discuss its principles. Only through disciplined practice, persistent effort, and real engagement can you master skills needed to serve society effectively. Your efforts today, your participation in moots, and your dedication to ethical advocacy will shape not only your future but also the future of our legal system and the society we serve. Thank you, one and all. I wish you all great success in your journey ahead. Nandri, vanakkam.